So welcome to this CEDR Insights webinar. CEDR, as you may know, is an organisation that is dedicated to both new ways of finding approaches to resolve disputes and very much has mediation embedded in its core. But we are also a not-for-profit that offers different services. I'm going to just very quickly share that with you. So let me have a go at doing that with the joys of technology. So hopefully you can all see that new slide. And that essentially is CEDR is here as a resource to help. We work with lots of individuals, hundreds of law firms and hundreds of organizations every year. We get many thousands of case referrals. And what we're doing is we are both providing mediation and dispute resolution services, but we are also as well training. We're obviously very well known for our mediation accreditation, but we also train in negotiation as well. And we will consult with people on their different problems. And we've been doing that for a long time, for 35 years now. And so I think that's enough about this. So I'm going to stop the share. So let's stop the share and hopefully you can now see us. So the topic we're talking about today, which is a really important topic, and it is the changes that have happened since Churchill. And just thinking about it, and my history with CEDR goes back 20 years. I mentioned CEDR's been around for 35 years, but it is about 20 years ago that a lot of the first big changes in mediation happened. We had the Wolf Report and access to justice, and then the reforms that came along with it. And then we had the Dunnett case law and Halsey, and the I think the pre-action protocol change in 2008 was quite helpful in making people think about mediation differently. But we haven't really had a step change in this area for a while. And then we've had Churchill, and now we've had I'm going to get it wrong. It'd be so much easier if we could just call it super dry. But DHK case has come along, and the world does seem to be shifting. And as those of us who are delivering dispute resolution services, whether as lawyers or mediators, it's something that it's important for us to be on top of. And therefore, that's why I'm very pleased to be joined by two people who are very eligible to talk on this topic. I'm going to do a brief introduction and try to do them justice. But Tony Allen has a huge track record in this area. He was a solicitor for many years with Bunkers. But then in the, I think I'm right in saying, in the last century, Tony turned his eyes to mediation and became a mediator, and then for a while was a director of CEDR. But he can also, he holds a pretty special distinction of almost single-handedly, and in fact, pretty much single-handedly, creating two sectors of mediation: personal injury mediation and clinical negligence mediation. He's been a prolific author, and he's also, I can't, there's too many books of his for me to recommend. I'd be on the call for too long. But in addition to that, he's also spent a lot of his time campaigning around attitudes and looking at where the law might have potentially got it wrong. And as part of that, he was he has been advising on different areas. In particular, I'm thinking about the report. He was on the ADR committee of the Civil Justice Council and was influential in that over a decade ago. But talking about the Civil Justice Council, we now have the current ADR lead on the Civil Justice Council with us, Amrik Kandola. So Amrik didn't quite make it into the last century. I think he accredited as a mediator back in 2000, but his background is having been with Eversheds, where he led a very successful construction practice before becoming a full-time mediator. And at Eversheds, he was on the board as well. So Amrik has a real sense in terms of the discussions that are happening at the moment in relation to where mediation fits within the civil justice system. So I'm not going to talk anymore. You want to hear from the experts, so I'm going to hand over to them. And I think I'm just going to ask a very open question, as any good mediator would do, to ask them to reflect on how they feel about where we are at the moment.
Tony, shall I kick off on that?
Why don't you?
Yeah, perfect. So, hi everybody. Thank you very much, Andy, for that very nice introduction. And in terms of your question about the overall effects of Churchill, I think it would be an underestimate to say that Churchill has been seismic in terms of its impact on how the civil justice system now perceives mediation and what mediation's role is. And I should say, when I say mediation, I'll keep doing that today because primarily we're talking about mediation today, but this also includes other forms of ADR as well, because Churchill wasn't just about, it actually wasn't about mediation at all. It was about a different type of internal dispute resolution process in that case. But I think the effects have been of Churchill have been seismic. But actually, I think it's important to understand partly what was the background, why Churchill happened the way it happened. And I think in that respect, I quite like to just refer back, Andy, to, you already mentioned this, but the Civil Justice Council produced 2 reports, either side of the COVID pandemic. Apologies for a reference to COVID there. But the first Civil Justice Council report was issued on the 1st of December 2018. And Tony, you played a really, really important part of that report. And I'll be interested to see what you think about that. But it's interesting to note that the conclusions of that initial CJC report on ADR was that there needed to be greater awareness of ADR, not only amongst the public, but also amongst the professions, that's the legal profession, and also the judiciary. And I thought that was really interesting that the CJC concluded that, but it also needed to be better availability of ADR in terms of funding, I guess, logistics, also the quality of mediators, how they're regulated, and also affordability, but also this idea of encouraging mediation. The problem with encouraging mediation, either by government or by the judiciary, was the fact that there was a case that was kind of a bit of a problem. You know, and that case was Halsey, which basically decided that to mediate or to order the parties to participate in some form of ADR was a breach of Article 6 of the European Convention on Human Rights, which therefore meant that the Civil Justice Council did a further report in 2021, which was specifically aimed at compulsory ADR, and concluded, and it's a pretty good read if you get a chance to read it. It covered a lot of ground, but ultimately it came to the conclusion that Halsey was probably wrongly decided and that the parties actually could be required to mediate. And actually there were good reasons why parties should be compelled to mediate. So kind of that was the kind of the background that kind of existed, kind of leading up to what turned out to be Churchill. Tony, just pause there to see.
I would say we were very much involved in that.
Yeah.
We were quite deliberately conservative, I think, and cautious in the original report back in 2018. We weren't actually at all agreed that it was right and proper for courts to order parties to mediate. So we were quite cautious there. And I was, for one, very glad that the CJC then proceeded to commission the compulsory ADR report. One of our members on that first report was involved in the second one as well, to give a degree of continuity. And I thought the second report was very persuasive, and it said, frankly, what I've been saying in articles and books for a very long time, since having made the written CEDR submission to the Court of Appeal in Halsey back in 2004.
Yeah. And actually, it's important to recognise I think it's really important to recognise the work that the CJC did, and also my predecessor, who was the ADR member, Bill Wood, KC, was really heavily involved in both of those reports, and led and was chair of the working groups that kind of did the background in order to produce those really excellent reports. So coming back, Andy, to your kind of primary question, and the reason why we're here today talking about Churchill is that the effect of Churchill has been seismic, and you can see that in the way that it's been dealt with by changes in the CPR. And, you know, I think the fact that changes have happened to the CPR is a big deal. It's not often that a case that is dealt with by the courts leads to changes to the civil procedure rules. And not just that, but change to the overriding objective, which is the fundamental cornerstone of the civil procedure rules, which is all about dealing with cases justly and at proportionate cost. And here we have a case that has directly led to changes to the overriding objective, so that, you know, it's now part of the overriding objective. Rule 112F, for those that want the reference, the court now has the power to promote and use for parties to use alternative resolution, and indeed under 1.4, Rule 1.4, the power to order or encourage the use of parties and facilitating the use of mediation. So I think it's really important to think, just in, you know, the Churchill case kind of led to this monumental change in something which has been, you know, a mainstay for so long and not been changed for so many years, which was the overriding objective.
Can I add, I think that it's not just the power to do it, it's also the responsibility to do it. I think that's the key to the word promoting. The word promoting ADR is actually mainly aimed at the judiciary. Using ADR is directed, it seems to me, to the legal profession. But there's no doubt about it, over the years since Halsey, and indeed in the Halsey decision itself, but revealed the fact that there are certain judges who take different views about the place of ADR in civil justice. And I do not think that those judges will have the same freedom of movement to, if I may say so, indulge their own personal opinions about it, because they are placed under this responsibility to promote it under the overriding objective.
Yeah, I'm glad you said that, not me, Tony. But you know what? You're absolutely right. And it kind of flows into not just changes to the overriding objective, but the fact that the court's powers of case management, which were dealt with in Part 3 of the CPR, have been also changed as a result of Churchill. So you now have situations, you now have a specific provision in Part 3.1, which provides that the court may order the parties to engage in alternative dispute resolution. And it's quite interesting, I think, Tony, that the court, that in the CPR here, the specific word used is engage in mediation, whereas in the overriding objective, it talks about using or promoting the use of mediation or alternative dispute resolution in more general terms. And I think that must mean more than just turning up. Engage means you must do something positive, you know, to demonstrate that you're actually, you know, bought into this idea of alternative dispute resolution mediation. I don't know what you think about that.
Well, engage is a word that came into the amendment rules as they were finally approved in October 2024, as a result of the consultation process that the CPRC set up in the spring of 2024. I can't remember what the original draft word was, but engage is certainly a stronger word than that, and I entirely agree. It means a proper interaction with the process. And calls for more than just sort of a tick box.
Yeah, I think that's exactly right. And the CPR also then repeats that obligation for, not that obligation, but the power of the court to order the parties to engage in mediation when in the specific practice directions that deal with the three main tracks, so the fast track, the intermediate track, and the multi-track. So CPR 28 deals with the intermediate and the fast track, and the wording is very similar. It's about ordering the parties to engage. But I think it's really interesting when you look at CPR 29 2, which deals with the multi-track there, and I just want to make sure I get the wording right. It talks about the fact that when giving directions, the court must consider whether to order or encourage the parties to engage in mediation. I think, Tony, this goes back to your point that perhaps there's been variable historically, perhaps maybe some parts of the judiciary were more in favour than others. But whether they're in favour of it now, they must consider, certainly in multi-track cases, they must consider, and I think that means not just an idle inquiry, but a really positive discussion and assessment, perhaps at the first case management conference, maybe, whether or not mediation should be used. So I think that's going to be something that is going to be really important, both for judges, but also for party representatives to understand that this is going to be a really, really important part of discussions in those first case management conferences.
Very much so.
And just on that point, there is a very specific provision. Well, if we also remember that the CPR rules existed before Churchill, and the court has general powers of case management. And one of those general powers of case management is that the court can actually make orders without actually hearing the parties. Again, that's built into Part 3. So here's my thought. We might well get to a point, if we're not there already, where it becomes so commonplace for courts to order mediation that actually mediation becomes an order, or ADR is ordered as soon as a case is allocated. As soon as a case comes into the court system, rather than waiting until there is some kind of formal meeting between the parties and the judge. And just to give you a sense of that, there is a provision, again, I'm just going to refer here to the multi-track, but in the practice direction 29, which deals with the multi-track, it specifically provides at paragraph 410 that if the court is going to give directions on its own initiative, which means without a hearing, its approach will be, at paragraph 9, it explicitly says where it thinks it's appropriate, the court may give directions for ordering or encouraging the parties to engage in ADR. So I think there is a specific provision that already exists within the body of the rules that actually makes this point that there could well be orders for mediation which are just automatic once a case has been allocated. It'd be quite interesting to see if anybody on the call today has experience of that. I don't know if you've had any kind of.
Well, no, but let me add also the fact that it now features in CPR 3 means that the usual remedies for breach are also available, as discussed in the well-known case of Denton. The range of sanctions is exactly the same, depending upon the wording of the provision that has been breached, as it is in any other part of the CPR.
Yeah, well, actually, let's come on to sanctions, because you raise a great point there, and we have the specific provision that is now built into Part 44 that identifies the specific sanction and the court's ability to penalise the parties in costs where they fail to comply with an order to mediate or an order to engage in mediation. And that again goes back to this point that it's not just about being there. There's got to be some kind of positive engagement with the process. Now, I don't know what that means, and that's probably one for case law going forward, perhaps. But also there are other sanctions. And of course, again, you go back to the court's general powers of case management in Part 3. And the other thing that the court can do as part of its ability to sanction parties for failing to comply with an order of the court is to give in less orders. That unless you do something, for example, the case is stayed or something like that, or in a really extreme case, that the case is thrown out. Now, I can't see any reason why that kind of sanction can't be used in a situation where, for whatever reason, one party does not comply with an order of the court to either use mediation or, perhaps more controversially, engage in the mediation process.
I've got a bit more to say about that in relation to compliance with the pre-action protocols later on. But
okay.
So it was very much in the CJC's mind in that respect.
Yeah.
Changes.
So the other thing that I just wanted to sort of touch on briefly, I mean, we've looked at the changes to the CPR, and I think in terms of Andy's initial question to me, which is the effects of Churchill, well, we've had all of these significant changes to the CPR. The other thing that's been happening is that courts have now started making orders for parties to go to mediation, but there's been quite a bit of inconsistency, and certainly some of the noise that I'm hearing is that different courts or different judges are approaching this in a different way. Some are giving very detailed orders, some are giving not so detailed orders, and there's quite a bit of variation. And I think it's been acknowledged that that is something that probably needs to be resolved. And it's certainly been something that's been discussed within the liaison committee, which is the Judicial and ADR Liaison Committee, which interestingly is one of the things that came out of the 2018 CJC report, a recommendation that there should be some form of joint committee between ADR professionals and the judiciary. And that now exists. It's chaired by Lady Justice Sarah Asplin, and it's certainly been a conversation in the context of those meetings. And I know that there is in the process of being now published a document which effectively will be a standard order for directions for ADR. And I think that's to be welcomed. I think that will give a lot of clarity and a lot of certainty to the way these orders are going to be made. And also going with it, my understanding is there's also going to be a guidance note. And that guidance note will kind of couple of pages, and it will kind of explain what mediation is, how it works, how to find a mediator. And I think there's references to some government websites and also to the CMC's website. But it also talks about what happens and what the process is if parties manage to settle. And certainly one of the latest drafts I've seen talks about a draft Tomlin order and sets that out. And I think that's going to be particularly helpful for parties, who are not familiar with mediation, litigants in person. There may still be some lawyers, some law firms out there that perhaps don't know as much about mediation as perhaps they might. So I think that's going to be a welcome development when it comes. I think it's in the process of being finally drafted. Others may have better information. I think on that, I think there is a chat function. So if people want to make comments in the chat, you can. And maybe some of those points we can deal with then in the Q&A.
I think one point that's worthwhile making at this point is that the bogey word is mandatory. And everyone's, Churchill has led to mandatory mediation. I don't think that's correct use of language, except in one respect, which is what I wanted to ask you to comment on. It is mandatable mediation. The courts now have the power. They have obligations and responsibilities, as we've already touched upon, but they've also got the power within their discretion to make orders at various stages, and these may well be to some extent shoehorned or directed by standard directions. But there is not mandatory mediation in the English civil justice system. There is mandatable mediation. And the effect that this is going to have on the civil justice system is what this debate is all about. But there is, of course, one area of mandatory mediation, that's small claims.
And
a bit about that.
Yeah, just on the small claim. Yeah, so you're absolutely right, Tony. I should just say, in terms of it's mandatable, it might well be the case that in the months and years to come, as the courts become more familiar with this and more comfortable using orders for mediation, that it might become automatic as part of case management.
It's possible.
So that's quite possible. But we do actually have one area of the civil justice system where mediation is mandated, and that is the small claims mediation service. And that came through. There were various pilot schemes in relation to the small claims mediation service running for quite a few years. But in 2024, so not as a consequence of Churchill, but kind of running in parallel with Churchill, the small claims mediation service basically became meant that any claim that was issued in the small claims, which is basically claims under £10,000, all of those claims now have to automatically be referred to mediation. And that mediation is run by the government department, His Majesty's Courts and Tribunal Service. And that involves a 1-hour telephone mediation with a mediator trained by HMCTS and delivered by HMCTS mediators. I think it's a really welcome development in terms of the progress that we're seeing being made in terms of embedding mediation into public consciousness, because let me share with you the figures for 2025, January 2025, in terms of the performance of the small claims mediation service. So in January of 2025, 7,638 cases were referred to mediation. 5,425 small claim mediations took place. 1,946 cases settled. And in January, the run rate for settlement that was running at about 36%. And the average time from referral to the mediation actually happening is 4.5 weeks. Now, whichever way you look at it, the small claims mediation service is dealing with a lot of claims. It's settling a lot of claims which would otherwise be clogging up the court system, it seems to me. And I don't know about you, Tony, but I've spoken to people who've used this service, and they speak really positively about it. And they speak positively about it partly because they actually want to try and settle, and it's the only way the other party would engage with them. But it was a mandated process. But also because I think the mediators that are supporting this service do a really good job, and it's not easy to settle a claim in an hour. So a 36% run rate in terms of success, and actually that's going to go up because in the pilots they were running at about 50. But obviously, when you run this new system and you're dealing with thousands of cases, you get the usual kind of bedding in problems. And I think in time we will see those percentages get back up towards the 50%. And I
think you make a really good point there about the fact that because it's mandatory, it relieves the parties of the responsibility of choosing to elect for it. It takes away the fear of loss of face or sending a signal of weakness because people have to do it. And this is actually one of the hidden benefits of external pressure to use the process.
So that's kind of what my overall take in terms of kind of just looking at what's been the impact. So it's not just about the changes to the CPR, but what it says and how it changes people's mindset, but importantly how it changes the judiciary's mindset, legal practitioners' mindsets in terms of what the role of mediation now is. And obviously practical things like a standard order for directions, with a guidance note, all of these things are really going to help. And in terms of this conversation about mandation, well, we're having it. I mean, my own view is I really, really hope that the government's interest in mediation doesn't stop at small claims, and actually that it looks at other areas, perhaps of claims of higher value or perhaps in specific courts where something similar can come in. And I guess on that bombshell, Tony, I probably should hand over to you to talk about the DKH and Manchester City case.
I was just recalling, of course, that there was the government itself perhaps needs to look at the mirror itself, because of the government ADR pledge, which was made many years ago, seems to be one of those things that is sort of quietly put on a shelf in the Ministry of Justice and forgotten about. But no, my job is to just talk about two things. One, briefly about recent cases that have, in a sense, shown the way the things might develop, and the practical way in which Churchill, and more particularly the changed CPR, is going to affect the situation. And secondly, to talk about pre-action conduct and the pre-action protocols. On the question of cases, Andy Rogers has already mentioned DKH Retail and City Football Group, an absolute classic situation in which parties were in a knot over sponsorship deals on football shirts, as we're touching on football, to the grief of some on last night's results. Although it was to be a swift hearing, it wasn't going to be a particularly long trial. Very substantial costs were spent upon this disagreement between these two parties as to whether or not there was an infringement of trademarks. And it came to a pre-trial review, a relatively rare thing for the outcome of a pre-trial review with the trial judge being reported. And it is reported on Bailey. You can get the access to it, and we'll send you a reference to it if you haven't seen it. And one party wanted to mediate, and the other party said it's too late, too much money has been spent, etc., etc. The judge said, no, look, I think a short, sharp mediation now is worth trying. Try and fit it in before trial. It was in the months leading up to trial. And so he actually positively made, as far as I know is concerned, the first public order by a High Court judge to parties to mediate, empowered to do so by Churchill. The touching thing is that there's a postscript to the judgment after which he said this, to say the parties reported back to say that they had settled. And so again, it just goes to show how relieving people of the obligation to take the initiative about mediating saves their face. They can get involved with it in a confidential atmosphere without any fear that anything that they might say by way of concession could be reported to the judge if it doesn't settle. And given that atmosphere, very often, in our experience, very substantial gaps can be closed because a commercial advantage perhaps emerges which hadn't been discussed before and is not part of the litigation, and the case settled. So it's a very interesting and exciting case. Set it against something that's read so in such an antediluvian way, a case called Ascensos, which was decided in the High Court well after both Churchill and the changes in the CPR, where neither Churchill nor the changes in the CPR were mentioned by counsel for either side or by the judge at his judgment, who said, oh, well, I don't think I'm going to sanction someone for refusing to mediate. It smacked of the bad old days of Halsey. It smacked of frank ignorance about the developments in the law that anyone who is in touch with this area should have been able perfectly well to articulate. And it underlines the fact that it is really important for litigators to understand this branch of the law so that they are armed with the cases that will support what they say. My only hope is actually that the changes in the CPR, the changes in what is happening, is going to make that kind of case completely obsolete. The kind of case that trails on to the very end past a trial, and then you have a lengthy costs hearing at the end of the trial where people are arguing on the point of a pin about whether someone really was or wasn't guilty of unreasonable litigation conduct, where someone will stand up and say, of course, it would never have settled. And if that was not accepted by the judge, then their client would be receiving a cost sanction. So, I mean, such an unreal kind of discussion.
And actually, Tony, that kind of plays back to the 2018 CJC report, which talked about at that stage the fact that there needed to be greater awareness of mediation. And normally we talk about that in the context of public and the public consciousness, but actually it's, people either within the judiciary or in the professions who just simply don't think about it. And even though we've got the CPR changes, that there is still a job to be done to change people's attitude towards mediation and actually getting it into the psyche that it's something that should be thought about all of the time. And those two cases that you mentioned are really good examples of, even post-Churchill, that knowledge, or that kind of in the moment knowledge that we should be thinking about this is sometimes not there. So actually being told to do it by a court, is actually quite empowering, because it takes away, as you say, the obligation that we should be asking for it or doing it.
So let's move on to talk about the pre-action protocols, because of course, unless and until a case has been issued, at frankly huge expense so far as court fee is concerned, the courts have no control. Other than the fact that has been clear since the civil CPR first came in 1999, that the courts can take into account unreasonable pre-action conduct when they're making costs orders at the end of the day. But I think we would all accept that pre-action protocol obligations have been have not been enforced enthusiastically. And part of the reason for that is the language in which they're couched. It's all about, you should do this, you may do that. And when it comes to considering ADR in any of the pre-action protocols as they stand at the moment, you should consider whether some form of ADR would be appropriate. It's pretty wishy-washy language. And it's hard to say, perhaps other than in a flagrant case, that someone is really in breach of an obligation in relation to that which might merit consideration of a sanction. But, and indeed, there are hardly any reported cases that I'm aware of in which some sort of sanction has been imposed for someone who didn't behave pre-issue. So what's happened in relation to this has been two reports. The second one divided in two, just to make things complicated, coming out of the Civil Justice Council in relation to reform of the pre-action protocols, which were an invention, of course, of the Wolf reforms and first came into force in certain limited respects in 1999. There are many more now, and of course there's the practice direction pre-action conduct, which governs cases which are not covered by a specific protocol. And interestingly and oddly enough, Churchill was one such case. Churchill was a nuisance case involving Japanese knotweed, which is not covered by any of the specific sector protocols. So after an interim report which consulted widely, the Civil Justice Council Working Group produced the first half of its findings on pre-action protocols in August 2023. It's a good read. A lot about digitization of pre-action processes, which I suspect is something that's going to take an awful long time to make work, even if it does when it's done. But also talks about the relationship of pre-action conduct to subsequent litigation conduct, and really challenges the use of optional language. What the real message, which is like yours, Amrik, coming out of CPR 29 under the multi-track, the word to be used is going to be must. People are going to have to do things under the pre-action protocols, and there is quite, we don't know the precise details yet because the detailed protocols have not yet been drafted and issued for approval. But there is a new general pre-action protocol which is proposed to replace the practice direction pre-action conduct, which effectively talks about three stages. One, notification and information exchange, and makes remarks about how one can do that adequately pre-issue. Secondly, a dispute resolution phase. And that is going to be mandatory, and I use the word mandatory as well. You are going to have to engage in a dispute resolution process. And it distinguishes, interestingly, between two different types of process. One is a process managed by a neutral, like mediation, like neutral evaluation, like ombuds, and those that are not. And those would embrace direct negotiation, joint settlement meetings, arm's length contact like Part 36 offers. And what it says is this, that if you are later placed under a mandatory obligation to mediate, and as we've heard, it's only small claims where this actually is, that there's an actual mandatory mediation later on, you will not have to do it again if you did engage in a dispute resolution process which was managed by a neutral. But you won't be exempt from that if you did one of the others, joint settlement meeting, negotiations, and all of that. So it means, if this recommendation is implemented, that people who have mediated before may not have to do it again. People who haven't had a third-party managed process might well be more readily ordered to engage in it after issue of proceedings. Now, actually, there's been a relatively recent case where judges have said, look, you know, even if you've mediated before issue, it may well be a good idea once you've got more material available to yourself, exchange of witness statements, exchange of experts' reports, for you to do it, to try it again. And that particular case is called Hayes and Hope, H-E-Y-E-S, and we'll send details of these references to you after today, where the judge said that very thing and ordered a stay for a second mediation later on in the life of the case, once it had been issued, although there had been a mediation prior to issue. So that's the kind of thing that emerged out of the first part of the final report in August 2023. It was, of course, issued 4 months before Churchill. So all they had to go on in relation to powers of the court was what was in the compulsory ADR report from the CJC a year earlier. But the second report came out in November 2024 and says, in effect, we think that all our recommendations are perfectly consistent with what Churchill and the amended CPR have brought about. And we invite you to enthuse about the kind of recommendations you've already made. It was a much shorter report than I certainly personally expected. There was just a brief chunk which coordinated what they had said in their reports with the Churchill and the changed rules. And then there were a series of reports from subgroups as to their own special pre-action protocols. And I'll come back to those briefly in a moment. What Churchill did, though, frankly, is to render completely wrong a statement that appears in 5 of the existing protocols. Those 5 are the 4 protocols dealing with personal injury, clinical negligence, package holidays, and disease and illness. And that statement reads as follows: it is expressly recognised that no party can or should be forced to mediate or enter into any form of ADR. If you go to any of those 5 protocols, you will find in the section under ADR that sentence still there. It is wrong. And it is frankly a disgrace that it has remained there for well over a year since Churchill. I have a suspicion that things are being done about it, but it cannot afford to await a wholesale redrafting of all the individual pre-action protocols. It's something that should be cut out at high speed, in my view, and it's an embarrassment to the fact that these protocols are actually saying something that is positively not the law and presenting it as if it is. There we are. I've said my bit about that now, and we'll see. Watch this space. I search the protocols nerdily every week or so just to see if they happen to have taken it out, but there's no sign that they've gone yet. So just going back also to the final report, part 2 of the November 2024 report, they don't deal with all of the protocols. There are 3 or 4 that haven't actually been discussed yet. The change to should, from should to must, is confirmed. Interestingly, there is a sidewind about whether negotiations to set up a mediation should be treated as privileged. People quite often will put without prejudice on correspondence that deals with whether or not you're going to mediate and how and what terms. There's certainly suggestion from the construction and the construction working group that it should be possible for courts to have access to exchanges about the leading up, the setting up of a dispute resolution process. And that is also in the other piece of new drafting that appears, a business and property court pre-action protocol, which is drafted and appended to the second report.
And only just say that kind of makes sense if you think about under the CPR, the court's power to order parties to
yes,
or
absolutely.
engage. So there's got to be some kind of communication, otherwise how would the court know that the parties have done?
Yeah. There's one case. I mean, there's one case where that was done back in 2023, in fact, called Jones and Tracy, where the judge said, "I think I've got the right to see. Should not be treated as privileged. I've got the right to see what happened and why each party was trying to set things up."
But importantly, not the content of the mediation itself. I mean,
no, absolutely not the content of the mediation itself. And one of the drums that is beat throughout, one wouldn't want today to end without emphasizing it, there is absolutely no compulsion to settle. Yeah. I think, to be frank, thinking back at reading the judgments in Halsey, some of the judges in Halsey just thought that the reason that this might be, or perhaps the submission was made to them, apparently not on the authority of the Law Society who instructed counsel, that it was a breach of Article 6 was because, in effect, it was compelling people to settle. And that was, and would be, in my view, a breach of Article 6. The process is available for people to explore the possibility of settlement. And now that we have got many judges in the High Court, the Court of Appeal, who have actually were in practice at a time when mediation existed, I think we are increasingly finding that the judges actually understand what the process is about in a way that wasn't true 25 years ago. And I think this will inform the way decisions get made. On the individual reports from interest groups or subgroups about the certain areas that are special, these are quite interesting read. I personally expressed great disappointment about the content of the injury groups submissions. It seems to me that this is a large area of litigation which has never been swift to embrace the use of mediation, and they show little sign of enthusiasm in what they say today. I have a feeling that there is a surprise coming, because if, frankly, the CPR are taken seriously in the way they have been amended in relation to the overriding objective and the court's powers, it's going to happen. And it would be a good idea for those involved, the insurance industry, claimant organizations, to work it out in advance and work it out with people who know what they're talking about when it comes to mediation.
So I guess the key message there, Tony, is that as far as pre-action protocols are concerned, across the piece changes coming. There's going to be change in the language in terms of making it compulsory that the parties have carried out some form of exercise of trying to settle, some kind of engagement either with each other or with a third party. And I think that seems to me to be just a natural consequence that, you know, we shouldn't just be looking at the use of ADR once proceedings have been issued, but it actually needs to be something that comes in much earlier than that. And I guess my kind of thought about that is, an observation is, you go back 25 years ago, mediation used to often be talked of the option of last resort.
Mm.
Aren't we now seeing, as a result of the change to the pre-action protocol, almost bringing mediation almost into the conversation as the thing that you should first be thinking about when you're first, if you're a practicing lawyer, when you're first instructed by a client and you're talking about strategy and options, actually mediation has to be up there as one of the first things you need to be talking about.
Absolutely. And the fact is that it will only be in relation to pre-action deployment or refusal of mediation that the courts will really ever have any opportunity to consider whether someone should be sanctioned for turning it down. Once the case has been issued, then courts will be either of their own motion or on party application dealing with it. Just one warning to those who might be tempted to think it doesn't matter too much if I turn it down pre-issue, comes out of the final report part 1, where in relation to this business of imposing costs, sanctions for refusal. What has happened, indeed, what happened in Churchill itself, in the first instance, in front of the Deputy District Judge in Cardiff, was that he said, "Oh, I'm not going to make an adverse." He was quite plain. He thought that the conduct of the litigation on the plaintiff's side was bad and would probably attract a cost sanction, but he declined to order it at that stage. Oh no, that's something I'm going to leave for the trial judge, presumably thinking, well, it's just possible someone will come up with some sort of excuse, and maybe Mr. Churchill will win, and therefore it will be a little unfair to impose a sanction upon him for unreasonably refusing to engage in a dispute resolution process at this stage. What the Civil Justice Council report says is, come on, judges, be more robust than that. There is no reason why you shouldn't sanction poor litigation conduct at the time that it happened or immediately after it happened. Don't adjourn it until the end of the case. You've got powers in any hearing that lasts no more than a day to assess the costs, to order summary payment of those costs, and the CPR require a lawyer in those circumstances against whose client a party has been made to notify the client as part of their professional obligation, which is all a bit frightening, frankly. But I remember perfectly well when this provision, I'm probably the only person on this broadcast today who is old enough to remember that this came in as a provision shortly before the CPR were actually introduced back in 1999. And the effect of this was to empty the bear garden in the Royal Courts of Justice. Everyone used to misuse silly little applications for further and better particulars and all sorts of things, and thinking, great, we can play the strategic, we can play the sort of, the procedural game and try and get a little bit of a lever here. At the moment that this provision came in, where everyone could get, one party at least was going to get clobbered on costs and have to pay them straight away, all those applications disappeared. And the masters were just left with dealing with the half-day case management conferences instead. So that
it's a good thing. Yeah.
That's all I want to say about protocols. We may have some time for some questions.
We do. So there's been some various comments to me in the chat. I think Kelly noted, Tony, that you were responsible in the submission on Churchill from changing the wording from participate to engage.
That's right.
But that's then raised the spectre of how do you police what engagement looks like, and do either of you have views on how you might police or judge that engagement has taken place?
Well, I think I said before, Andy, that engage must mean something more than turning up. Now, what exactly that means, I think ultimately, at the moment, the honest answer is I don't know. I suspect at some point this issue will come before the courts where somebody says, actually, we tried to mediate, but for reasons, the other party is not engaged. Now, the interesting question there will be, and it goes back to Tony's point, is about, where does the line of privilege start or stop, as it were, in terms of the party's conduct? Because there's no compulsion to settle, and certainly nothing that is part of the actual core mediation could be disclosed. But if one party is deliberately just not engaging with the process and just literally doesn't do anything, at what point, there must be some way that can be brought in front of the court. Otherwise, there's no point having an obligation in the CPR to engage if you can't enforce it. So I suspect it's going to come down to case law.
It is. I mean, it's going to be difficult to say that someone didn't engage when they got to the mediation because of the confidentiality of the process, and one's got to weigh up the value of being able to criticise another party against the security of what passes. I mean, for the moment, I'd be content to say that engagement, litigatable engagement, stops at the moment that the party arrives at the mediation suite. I think if there is no engagement in terms of setting it up, or someone welches out at the last minute, that should not be privileged, as we've said, like the James and Tracy decision suggests, and arguments can be raised with the court if necessary. I've always taken the view that people have been dragged into mediations actually against their will for quite a long time, particularly by ADR dispute resolution clauses. The transactional lawyers enthusiastically stuck in a clause, and litigation lawyers are spitting and grinding their teeth at the fact that they're being forced to do this process that their colleagues set up in the first place, and so people have come unwillingly. It's up to us mediators to persuade them once they get there that it's worth staying. And I've always felt that was a responsibility I was capable of trying to discharge, whether successfully or not. And if I don't discharge it, well, then they go, and it's been tried. And a few kind of half an hour, I don't think I've ever had a mediation that lasted less than 3 hours. And I think that if there were the odd half-hour mediation is worth the price of keeping the confidentiality of the process.
Yeah, thank you. Just time for one very quick question, which was a particular type of dispute. So obviously, as mediators, we see bad behaviour coming up as an issue or part of the claim or defence. But in cases relating to harassment, civil cases relating to harassment, how do you think that's going to play out with mandatory, with compelling parties to mediate?
Well, I think one heaves a sigh of relief that the process is exceedingly flexible. I mean, I don't think I've ever done a harassment mediation, but I've done plenty of mediations where a claimant felt that appalling wrong had been done to them by a professional, and was exceedingly reluctant to meet them. At least we have the ability, when we're setting up a mediation, to make sure that people arrive at different times, if they're coming in person, geographically apart. The process does not necessarily need to involve confrontation or meeting. People sometimes surprise themselves after being there for 3 or 4 hours, to think to themselves that's a good idea for them to meet after all. But the fact that the process is not just simply you herd everyone into a courtroom, whether they like it or not, and can do things in an exceedingly flexible way, seems to me to be likely to make it possible for even that kind of delicate case to be dealt with.
Yeah, I agree.
Thank you. And on that point, we're exactly on time. So thank you very much, everyone, for attending. For those of you who put comments in the chat, we will try to get back to you on those questions after this. But thank you so much to our speakers for sharing your knowledge and thoughts and experience of being involved in the continuing journey of mediation and its establishment in civil justice. So thank you to Tony and to Amrik, and thank you everyone for attending.